I would like to emphasize that out of 194 countries, 137 countries have already in place the laws about personal data protection. And for this, this counts about 71% of the total countries. And there are 9% countries which are under the draft stage, where the laws are being drafted. So when if we just we combine these percentages, so it becomes to 80%, the countries where the laws are already there and the countries where the laws are in the draft stage. So it gives the significance and the seriousness of the topic that the countries and the worldwide jurisdiction is taken it very serious to have laws present in their countries. So now I'll go to the overview of law. This is a very important thing. To understand this law relates on tripartite interrelated relationship. There are three spheres. At the very top of the thing, there are a natural person like me and we all who are given extensive laws in order to protect our privacy. And the second end, there comes the users of data, personal data, who use personal data of the natural persons, who are called data controller and the data processor, and they have placed certain obligation, in fact, extensive obligation, in order to protect and secure my and your personal data. And then at the third sphere, here comes a regulator or enforcer. Under the UAE law, this is called data office, UAE data office, whose purpose is to enforce the law. So the natural persons have the rights, user of data protection, user of personal data have the obligations, and the data office has enforcement functions. One thing is very important and common among all jurisdictions regarding personal data protection law, that they have an extraterritorial applicability. What does it mean, extraterritorial? That means the Gdpr, which is General Data Protection Regulation of the European Union, are equally applicable in GCC or outside EU. Likewise, the UAE law is also made on this extraterritorial applicability. So a data subject who is domiciled or have a establishment in UAE, the law is applicable. So it's the local law. But the second and third points are important with respect to extraterritorial applicability. Controller or processor who are established in UAE and who are processing personal data of individuals in or outside the UAE. So the law is applicable when the data processor is inside UAE, but it is processing data of natural persons who are not present in UAE. So, likewise, the third one, controller or processor not established in UAE, but they are processing the personal data of natural persons who are present in the UAE. So it gives the extraterritorial applicability of the UAE law. The law is not applicable on certain data. Importantly, the government data, government authorities, health-related data, banking data, and the last bullet is very important. It is not applicable on the free zone. There are so many free zones in whole over the UAE, and the free zone who have their own specialized personal data. So this law will not be governed under, will not be applicable on the free zones. UAE Data Office has powers to issue exemption to certain establishments who are not processing very large scale of data. So probably it is a cushion for the SMEs or very small organizations to bring them out of the scope of this law. Consent is the single important element under which a data controller or data processor can process a data of natural persons. As I said, consent is the single important principle or the basis under which a data controller can process the data. But the law has some exceptions also to keep the business going on or to keep a balance between the business continuity and the enforcement of a law. Like, for example, necessity for public interest, personal data made public by the natural person himself, necessity to initiate or defend any claim of rights and legal actions, and few more. For example, health purposes, public health purposes, archiving, scientific research methods, and performance of obligations under a contract. And again, necessity for the compliance with obligation under any other law. If I'm required to comply with another law, for example, the tax law, and the FTA or the Federal Tax Authority asks me for some personal data, so I have to give it before, without seeking consent of the natural person, of the concerned natural person. And there's a room for the authority that executive regulation may specify some more exceptions to this list. Now, what are the general rules or the general principles to process the personal data? Very importantly, and the fairness, the data processing must be based on a fairness principle, transparency, and the lawfulness. And data processing must be for a specified purpose. There must be a specified purpose before the data controller or the data processor to process the data. And importantly, educate and restricted to what is necessary is the necessity principle. So the data controller can use or process the data for a specified purpose, but it should be limited only to that purpose. It should be educate. It should not be so much inherent data that he can process. And a data controller must keep the data correct, accurate, and up to date for the purpose. Some other rules are also, the previous slide shows a very general principle, but these are also the principle. For example, he has to ensure erasure of rectification of incorrect personal data, safety and protection, implementation of appropriate technical and organizational measures in order to protect the personal data which a data controller is being processing. And importantly, last bullet is, the data must not be stored beyond the period for which it is required. So once the purpose is completed, so the data must be permanently deleted. As I said in my earlier slides, Safir, that the natural person have got some extensive rights in order to protect his or her privacy. So what rights are available to the natural persons? Right to access to information. There's when we talk about the transparency and fairness, so it relates to this thing. The data subject must have a right to access this information. What information, my information is being processed by a data controller. I should know have a fair access. And right to request personal data portability, right to rectification or erasure. If the data is incorrect, I have the right to request the data controller to correct or rectify it. Right to restrict processing. The last two bullets are very important in these days, particularly with reference to e-commerce businesses who always try to profile their customers and to track their choices and trace their choices. So these are related to right to stop processing for direct marketing and profiling. It's quite common these days. And again, right to object to automated decision making. So we always see, for example, last year, April, if I book a flight for a destination, so this year, April, again, the travel agent or the airlines may give me an offer. So it's an automated decision making. So I have a right, if I come across a situation, I have a right to ask the data subject to not to process my information for automated decision making. It's a very important topic. A few of our colleagues have already talked in the earlier, the pre-lunch session about this. Under UAE law, there are two basic principles under which personal data can be transferred to outside the UAE. First is the advocacy level. Advocacy level means personal data from UAE can be transferred to another jurisdiction or to another country where there's an adequate level of protection. When we say adequate level of protection, it means that the protection at least is equivalent to what is provided in the UAE under the UAE law. And the second principle or the second basis under which personal data can be transferred outside UAE is the countries with whom UAE has bilateral or the multilateral agreements. But again, there are certain exceptions given in the law. Again, I repeat that these exceptions are to protect the business continuity. They do not want to stop the transaction or the commercial transactions. For example, subject to controls and requirements to be specified by the executive regulations through a contract or agreement binding the establishments in the other countries. So my colleagues earlier in the day talked about the standard contractual clauses within the Gdpr law. So this is the same in concept that through a binding contractual agreements, data can be transferred outside UAE. Some other exceptions are also there. For example, transfer is necessary for performance of a obligation and establishing rights before the judicial authorities outside. Transfer is necessary for the performance of a contract. Transfer is necessary for the performance of act relating to international judicial cooperation. and transfer necessary for the protection of public interest. So these are the exceptions. Lastly, it's a very harsh slide. It will not be giving a very good, maybe, impact to the audience, but I don't want to scare my colleagues. At the moment, the UAE law has not specified the penalties, the level of penalties, even there are no offenses defined. So a cabinet decision is awaited, which will prescribe the offenses, fines, and the sanctions. Just again, to highlight what could be, I'll just give 3 examples from other jurisdictions. For example, Gdpr in the EU, the maximum penalty is 20 million euro or 4% of the global turnover, whichever is higher. ADGM, Abu Dhabi Global Market, and Dubai International Financial Center. They have already, they are both the free zones, and they have their own specific law on personal data. So for the ADGM, the penalty is, maximum penalty is $28 million. DIFC is very lax, so it's only $500,000 for any offense. So this ends my presentation, and I thank you for listening patiently. Thank you.